Thank you, Mr. Chairman.
Thank you, my lord.
Yes, Mr. Nowrojee.
Thank you, my lord. Members of the court. My lord, may I turn first in reply to my learned friend, Mr. Ghatia's submission that the unique provisions of the election of the president is what we should be looking at. And he said that in that there was the provision to tally and then to declare the result. And he was referring to Article 138, 3, Sub-Article 3, Paragraph C. But he left out one very important part of that provision. And the provision is this. After counting the votes, it's 138, 3C. After counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. So that right in there, right in the presidential election special provisions, is the necessity for the returning officer, the second respondent, to verify before he declares. And we submit that this indeed was not done. We go a step further, my lord, and we say it could not have been done. This is the important consideration that we wrote to the IBC on the 10th of August, the day of the result, and that is to be found. It has already been submitted by my learned friend, Honorable Otiende Amolo, in his submission. It is the letters are to be found in the petitioner's supporting affidavit, Volume 1, Volume 2. And at page 207, this is what we wrote to the IBC, saying, you informed the Kenyans and the world at large that IBC had received over 40,000 forms, 34A, and about 170 forms, 34B. We have requested IBC for all these forms for purposes of verification. Members of your secretariat have informed us that they can only avail 29,000 forms of 34A. So that is a gap of about 11,000 34As on the 10th of August. As at 11 p.m. of 10th August 2017, which is now after the result. So after the result, my lord, 11,000 34As were not with the IBC. They could not avail them to us. Kindly request the Commission to expedite. Then the IBC didn't reply immediately to this, and on the 14th of August, we wrote again to the chairperson, which is on page 208, the next page, my lord, my ladies. This is a follow-up of our letter of 10th August. Until now, IBC has only furnished NASA with 29,000. So that is close to, my arithmetic isn't the best, 12,000. Forms 34A and 114. We urgently require the unsupplied 10,000 form 34As. So even between the 10th of August and the 14th of August, those missing 11,000 34As had not been supplied to us. We wrote this letter on the 14th. They reply then on page 209, to the Deputy Presidential Agent from the CEO, Commission Secretary, Mr. Chiloba. Reference is made to your letter of 14th August, requesting to be supplied with the remaining forms that were not supplied earlier. The Commission is in a position to provide all the requested Form 34B immediately, so they could give 34Bs immediately. We are, however, not able to supply Form 34As at the moment, but the same shall be availed to you as soon as possible. My lords, my ladies, this is now 4 days after the result. If they do not have, those are not available. I use his words, they are not able to supply 34A at the moment. How then did he get to the result? I will come back to this aspect, but at this moment we submit, in reply to the submissions made on Article 38, that the returning officer, the second respondent, did not verify and therefore did not comply with Article 38, which is the article that the respondents themselves say it had been followed and is to be followed. And we say that this, therefore, could not lead to a result, and that the declaration of result was therefore in violation of Article 38 and could not give forth of a lawful result, a lawful declaration. I'll come back to these forms in a short while and turn then to the question, where were then these forms? Why were 11,034 A's missing for 5 days after the election? 6 days, actually. 6 days after the election. And we saw here a chart by the respondents of what happened at 5:07, what happened at 5:08, 9, 10, etc. What would have helped the court would be to have a chart of what happened step by step. Let us take the 34 A's in the best of conditions, my lord, giving them the benefit of any doubt. And 34 A's were supposed to come from these 40,000 polling stations to the tallying center and then from constituency to the national. And when they arrived there, presumably immediately after the counting, and my learned colleague, Mr. Molo, has pointed out, what were the means of transmission? That already creates another area of hopeless doubt, which has not been cleared. But let us assume that they were transmitted electronically, and when that predictably failed, they were going on with another system. But whatever it is, 34 A's had 41,034 A's had to reach the National Tallying Center. And they reached on that day. Maybe they reached on the 11th, on the 10th. My lords, then we do not know what happened to them. On the 14th, on the 11th, they're not there. 12th, they're not there. 13th, they're not there. 14th, they're not there. My lords, they have gone into the IBC headquarters, and then we hear no more about them until later, and I come to that. My lords, there is in the mid-Atlantic Ocean, near Bermuda, an area where ships that have gone into this area never seem to come out, and nobody knows what happens to them. This is called the Bermuda Triangle. And the Bermuda Triangle is notorious for the absence of knowledge of what happens to ships that go into this triangle. My lords, we have emulated that, and this is the Beauma's Triangle. 34As come in, and then they disappear. We don't know what happens to them. My lords, this is not law, this is not accuracy, this is not verifiability, this is not transparency, this is something, unfortunately, that can only give rise to a very questionable sequence. And it is this, my lord. Everybody knows, and the Honorable Mr. Kerry, who is a gallant and honorable person, himself thought that it was very simple. All you have to do, if there is a problem in the result, go back to the 34As and the discrepancy will come forward. And those people who have an interest in this, those who have an interest in this, know that that's the purpose of 34A. We were closing gaps everywhere, loopholes being closed. But, my lords, suppose you do the reverse. Instead of changing the result to the 34As, suppose you change the 34As to match the result which you have given. Then, when people go back to the 34As, the result, false result, and the 34As will match. But only, my lords, if they are false 34As. And, my lords, in order to have 41,000 false 34As, you need time. You need different
Sorry, my
papers.
lords, I know I'm not supposed to interject, but is that not a new case? Is that not a new angle in terms of changing the time?
Sorry, what's your...
The issue is now, in terms of changing the time, my client has an interest because now you would need the time to change, that's what I'm hearing, the Form 34As to match, as it were, with the Forms 34Bs. Why I say that is that my client's agents were present when the signature was being done, or rather appended to the Form 34A. That's yes.
My lord, he is not a party to this petition. He is not the custodian of the interests of either the person who's been declared, or the IBC, or the petitioner who is the candidate. He has no standing to make any interruption, my lord. My lord, I go back. So that the question is, you need time, and that is what may have happened. That is what could have happened, because, my lords, your lordships and your ladyships have no other evidence before you, and the only person who knows what was being done is the second respondent and the first respondent, and they have not chosen to explain this Beauma's Triangle missing, and the law, presumption in the law comes into place. A person who has special knowledge or the custody of evidence in his own hands and is not producing it to the court, the presumption is that the evidence he is holding is adverse to him. And that is the presumption that the court must draw in law, in common sense. My lords, your lordships and ladyships every day in your long careers sit and listen to lawyers and litigants coming before you and constantly twisting. But here is the question of hiding, and you all have enormous experience to know that litigants can do this and often do this. And you all would look beyond what is being put forward and say, what is actually going on? What is the common sense? What do we as people of the world see in this? And that is what is happening, we submit, that Form 34As were being held over for a purpose which can only be unlawful. I do not have to make any accusations, my lords, my ladies, against anyone. The mere fact of not disclosing what had happened to this can draw only one conclusion, that it is unlawful. And that is not a free and fair election. My lords, my ladies, not only did they not verify, but now we come to the other part of the evidence that Mr. Otiendo Amolo had brought forward. Why should there be Forms 34A, which when put under the machine show different names? That some of them show a barcode, some don't. Some do show somebody else's use of these things. So why was this necessary? If these were original 34As, then there was no reason for the forms to be other than the forms of the IEBC. And secondly, there would be no reason for them to vary amongst themselves. One with this name, one with another name, one with a different code, one with a different name of the candidate, and so on. So that, my lord, the evidence that they themselves have given us, which we have now passed on to the court, shows, my lords, that this is a management of the election which is heavily unlawful in places. It is more than careless. This is not how elections ought to be anywhere near being carried out. And we submit that from this missing evidence, there can be no declaration of the result that can be lawful. And it goes a little step further, my lords and ladies. It is this. This type of presentation, which the respondents have done on a long time, is not at all unusual. And to stop that, to stop the chairperson, returning officer, tallying officers, to say, we got them, we put them together, and we announced them. That was exactly what happened in 2007. And it led to a predictable result. And, my lords, the law is, therefore, that when an election official makes an entry into any document, in this case, an entry into a declaration of result, he must have a belief in the truth of that entry, so that he cannot say what Mr. Honorable Kivitu said. Mr. Kivitu, do you think the president has won this election fairly? And he said, I don't know. On international television. And that is what they say, because, my lords, there is so much silence. Mr. Mollo was right. They came and said the election was held with secret ballot. We had never said no, but they put it forward. We didn't do this. We had never said so. But they never come and say, we believed in this. Because they know that that statement in a court of law or in any other place is actually, my lord, an entry which does not carry that belief in the truth is actually now a criminal offense under the Election Offences Act. We have not sought any such declaration from the court, but we are saying that a conduct by the returning officer, which is conduct which is forbidden by statute, is of itself unlawful. Whether he is charged, not charged, whether there has been a claim for it or not, it is an unlawful step taken by him. My lords, can this not only did he not say that he had any belief in it, but the question is, from the material, are there any reasonable grounds for believing that that result which was put in the entry and the entry then announced was reasonably grounded? My lords, we say, no. Even the facts before him, he himself knew, my lords, that over 10,034 A's were not available to him, even at 14th August, and certainly not on the 10th of August when he was announcing the result. And any returning officer, much less a presidential returning officer, who is announcing a result without the 10,034 A's, cannot reasonably believe in the truth of his entry. Secondly, my lords, if these primary documents, as has been said by the respondents, primary, and as Mr. Kerry thought, were the right place to check, if these are missing, my lords, can there be a genuine 34C? Because 34As go into 34B, create 34B, and 34Bs create 34C. How then was that entry made? If 34As were missing, 34Bs could not have been created, and 34Cs. And if 34Bs had been created with missing 34As, then one of two things: the 34As were present originally and then have gone missing, which creates a more serious doubt, and which a court cannot then disregard and confirm an announcement so that the head of our state would sit in his office on the foundations of an announcement which was built upon the primary documents to the extent of 10,000 being missing. Or being unlawfully held, or being unlawfully treated, so that when the scrutiny comes, that circle closes correctly. But after there has been some doctoring. My lords, the electronic images of 34 A's were not sent when the 34 B's were sent. And all we got, my lords, was this extensive explanation of the electoral law being changed and what happened in the IBC and what their discussions were. No, my lords, that does not explain anything. What is important, my lords, is that the 34B, they have admitted that 34A's images did not always reach the tallying office. My lords, there are a whole number of steps that were wrong or missing or not completed, but I emphasize these important ones and say what is then happening in relation to this. There cannot be then any reasonable grounds if he himself has not said there are reasonable grounds. The court may look at his own grounds. The court may look at other aspects and see maybe there were reasonable grounds for him to do what he did. We submit quite the contrary. Not only are there no reasonable grounds for a true belief in that result, in fact, it raises suspicions which should never come from that institution itself. My lords, in relation to this then, I turn to some smaller aspects. The court had asked the issue of the dying declaration issue from the video there. My lord, it's of course not, as the court pointed out, not a dying declaration. But, my lords, if it is possible, may I draw the attention of the court to Section 33 of the Evidence Act, Cap 80. Statements by deceased persons made in the course of business. Here, so it says, when the statement was made by such person in the ordinary course of business, and in particular when it consists of an entry or memorandum or statements made by him in books or records kept in the ordinary course of business, or in the discharge of professional duty, or of acknowledgement written or signed by him for money, goods, etc., this same is admissible by Section 33. Here, it was made in his official capacity as an official of the IBC in the course of his normal business. Thank you. So that, my lords, it is admissible by virtue of the Evidence Act itself. Sorry. My lords, the submissions from the respondents were then aimed at saying, look, we've counted the votes. 2 and 2 make 4. And the gap is 500,000. Mr. Otiende Amolo has dealt with that, my lords. It is a concentration. Apart, your lordships will see when you weigh the submissions from the respondents, that it is concentrating on first procedural anomalies. Their affidavit is not this way, their affidavit is defective, the numbers are so small we added them up, the election was held with a secret ballot, etc., etc. My lords, there are more fundamental things that are wrong with the conduct of the first and second respondent and the benefit of that wrongdoing which is accrued to the third respondent. And they are putting forward numbers. The gap is so large. The test is, and my learned senior pointed out that they had taken all sorts of criteria, and the right criteria was that there should be wrongdoing and the numbers should be affected. My Lord, numbers are not the only test. Not only is the statutory provision subject to the Constitution is very clear. There are other tests in this Constitution, and they are the tests in Article 86. My Lords, it's known to you by heart, but whatever voting method is used, the system is simple, accurate, verifiable, secure. My Lord, it should not be so secure that they keep the 34 A's for 5 days. Accountable and transparent. It was none of that, my Lord. Then, my Lords, it was submitted in this respect that the numbers alone should be the test, because this is all about numbers. It is, again, in Article 81. There is another test. The whole of that article, my Lords, that the electoral system shall comply with the following principles: free and fair elections which are administered in an impartial, neutral, efficient, accurate, and accountable manner. My Lord, these are not the Constitution is not putting simply highfalutin principles. The Constitution is going down to 34A and down to the voting paper. Are you doing it accurately? And are you doing it in an accountable fashion? And are you doing it in an efficient fashion? Holding 34 A's for these number of days is neither efficient nor lawful, etc. Then, my Lord, 38 itself, 138 itself, which was the third respondent's thing, also requires the same principles, that they shall tally and verify and then declare the result. And so, my Lords, the tests which your Lordships will apply to what is going on here, all placed before you. Where is the smoking gun? My Lords, no person who is trying to manipulate or interfere with a process that gives rise to the highest power in the country is there for waiting to give us the smoking gun and photographs of it and a video possibly. No, my Lord, there is a bigger test. And the test is, who will benefit by all this wrongdoing? And has the second respondent, the first respondent, and the third respondent placed before you any material which can shift, not the burden of proof, my Lord, shift the unavoidable conclusion that something wrong has gone seriously with this entire process? No, my Lord, that is a more important test. And that is what has happened in this. My Lords, I turn then, without in any way admitting the submissions of the respondents, to the question, my Lord, to the submissions of my learned senior, Mr. Ahmed Nasir. My Lords, it was my learned seniors, seniors' submission, my Lords, that you could only upset the result if you found fault with the voter. 99%, he said, of these cases are with the fault of the voter. My Lords, that is not correct. It's not correct factually. Firstly, my Lords, it is not only, it's not any submission of ours that is at variance with this submission. The Constitution itself is in variance with this. Article 81, my Lord, talks about, and this is very important, it says the electoral system, not the voting, not the counting, not the tallying, the electoral system shall comply with the following principles. So that, my Lord, 81 does that. 86, so it's not only the voter, the whole system must be proper. 86, at every election, the Independent Electoral and Boundaries Commission shall ensure whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. And see this duty, my Lord, because it deals with the Form 34As as well. And the Commission shall ensure that D, paragraph D, appropriate structures and mechanisms to eliminate electoral malpractices are put in place, including the safekeeping of the election materials. That whole correspondence, my Lord, is in breach of this article, this duty upon them, and they frivolously talk about that they came, and it is our fault, my Lord. It's our fault because when the matter came before the registrar, the second respondent, the first respondent, my learned senior, Mr. Paul Muite, said, we offered to give them all these forms. And they said, no. My Lords, they offered to give us these forms after the opportunity for malpractices was sufficient. They had already had time, and the matter came for directions much later, many days later after the result. So that righteously to offer us this and said we were obsessed with these things, rightly so. And they said the numbers will be all right. With what confidence were they saying that the numbers will be all right? They didn't have that confidence on the 10th of August, nor when we wrote on the 11th, nor when we wrote on the 14th. But their confidence returns now. So that, my Lord, we are not blind. We can also see. When a man goes into hospital, my Lord, carried into the trolley, he says, my leg, my leg. And it may well be that in the end, the leg is all right. But the doctors find that, in fact, the ribs were broken, perforating parts of his internal organs. Then you don't go to that man and say, you came into this hospital claiming for a broken leg, and you're a charlatan, and you're on a fishing expedition, because you went into the hospital saying one thing and let the doctor search out what it was. My Lords, these are not serious responses that come in. Secondly, my Lords, I go to the issue of my learned friend, Mr. Ahmed Nasser, and that was a very important innovation in law that he made. He was supporting the issue of RILA 2013 and the reliance by your lordships on the Nigerian cases. And he says, what's wrong with that? Nigeria is a superpower. It's many times our GDP. My lord, this is a very important legal principle. I think that your lordships can take judicial notice that China's GDP is over 100 times ours, and the US is over 99 times, and I think you all should now go and get some Chinese cases and some more US cases, and then decide this. My lords, my learned senior will conclude the funeral procession and oration.
Mr. Nowrojee,
So tentatively, we assemble back at 7 in the hope that the report will have come. Thank you.
My Lord, may I confirm that following your observations yesterday, the amicus are discharged at this point?
Yes, unless you want to listen to the report, yes.
We are most obliged.
Thank you.